Stand out. I'm Ayodele Uzubakun. Today on the program, court disqualifies Sylva as APC candidate for Bayelsa governorship election. And later on the show, 107 non-7 APC senators throw weight behind President Tinubu call for caution over academic record as Nigerian ambassador to Burundi tells Atiku to give up in his attempt to bring Tinubu down. I'll be hanging out with Babajide Kolade Otitoju and Asuko James. If you're ready, let the hangout start now. Thank you for staying with us. Let's begin with the political quagmire brewing in the camp of the All Progressive Congress, APC, in Bayelsa State. A federal high court sitting in Abuja has disqualified Timipre Sylva as the APC governorship candidate for the November 11 election in the states. Delivering the judgment, the presiding judge, Justice Donatus Okorowo, ruled that Sylva will breach the 1999 Constitution if allowed to contest again, having been sworn in twice and ruled for 5 years as governor of the states. Justice Okorowo held that if it wins and is sworn in, he will spend more than 8 years in office of the governor of that state. Jide, there's this thing about Bayelsa judgment, and then within the APC, they have this last-minute judgment. Like, it's not similar, but the one of, if you remember, David Lyon, a day before he was sworn in, knocked him out. This, I sense, might take us to the Supreme Court, and this will be very, very close to the election. And this is like a constitutional issue here, Jide.
Yes, the difference between that one and this is that it was PDP that brought the matter, that sent David Lyon packing. But in this case, it's an APC member that brought this matter. The Mesoyefa Kolomo, is the one who brought this matter, asking INEC to delete Sylva's name from the list. It's a very valid position that he has taken, because in the past, we had governors who spent about 11 years. I remember former governor of Kogi State, Ibrahim, what's his other name? Idris. Idris spent more than the 8 years that the Constitution stipulates. Former governor of Yobe State, Gaidam, also spent more than because Gaidam succeeded his boss, who died, after serving as governor for some time. He died, outside Nigeria. He took over as deputy and then came in twice for his own time,
first time or 2 times of 8 years.
After serving as governor,
if you calculate it,
he then started another 2 terms. So making him effectively spending more than the stipulated 8 years. Before him, the Yobe governor, also similarly spent, just like the former Kogi governor, Ibrahim Idris, spent more than 8 years. So the Constitution, the Electoral Act was then amended to make sure that you cannot be sworn in more than twice, and you cannot do more than 8 years. The snag in this one is that Section 29, subsection 5 of the Electoral Act states clearly that only those who contested against him in the primaries can bring up this matter.
That the envisage is so.
If I sue him now, why would you sue him? It's just similar to those who brought up the matter and claimed that they were Abuja indigenes that Tinubu should not be sworn in.
Because he didn't have 25%.
It was a shitty.
That judge did not even bother sitting again.
No,
At the point he abandoned them.
bloody waste.
He left them, and the lawyer was abusing the judge.
You can only. No, it's the lawyer that was tongue lashed. You can only bring the matter if you contested against him. If not, by now, all of the people making noise on social media, they will have filed individual court cases against Tinubu since they do not like him. And they are not convinced that he won the election. They are convinced that it's the person who came third that won. They will have filed individual cases. Even the courts will not be able to handle the situation. So in saying that it is the person who lost that can challenge the outcome, they were very, they are very sensible.
That runner up,
So that,
or you are part of the...
Yes, you are the one who, you saw certain things, you were offended, you were wronged, you were cheated by the manner the thing went. You are the one who can sue.
Benefit from it.
Yes, you are the one who can argue that, oh, I could have won if not for some of these things that happened. So the law is very clear. Now, in this case, this person did not contest against him. So that is so the court will most likely rule on the matter of locus.
Oh, this person did not contest against it.
No.
The person that got this judgment.
Yes.
And the Electoral Act says...
Clear in section 29, section
you must 5. Contest in the primaries.
That is the thing.
This is not the end of this matter.
No. You remember Mama Taraba? This was similar. That time, some of the big lawyers said, no, this thing. But they know the law. These big lawyers, they know the law. But at the end of the day, what we said as ordinary laymen, they like to call us laymen, was what prevailed in the end. So we are not learned. But the law is written in English that we understand, so we can interpret.
The Latin one will go to Google.
Now, even if the judges of the appeal court decide that, okay, in spite of the matter of locus, we want to look at the merit of the matter, it may still not send Sylva packing. Remember what happened in Kaduna? And they said, okay, you abandoned your case. But they still looked into the merit of the matter, despite ruling that the PDP abandoned his case and PDP lost based on that level of technicality. But they still decided to go into the merit of the matter so that the Supreme Court can then decide whether they were even right or wrong in the manner they decided the merit of the matter. So that is what I suspect will happen. But again, the Supreme Court, as not just the court of record, but the court of policy, can decide that, this is what the Constitution says. If we leave this person, it will be in clear breach of the Constitution. It will be in clear breach of our Electoral Act.
In such this, they will not use their wisdom.
Should we permit him to spend 9 years when the law says you can't do more than 8 years?
Or should we allow...
permit him to get sworn in 3 times? When the law says you can only be sworn in 2 times? So it's a very tricky court matter. I don't know how it will be resolved, but
you can bet this will get to the Supreme Court, and the election is just like a month from this time.
When this thing...
It must get that accelerated hearing, and it must get to
this morning when I heard this, I said APC again. It's like they don't learn any lesson. They don't look at all the pitfalls and the things, the errors of the past for them to be able to...
Till tomorrow, I still feel bad for David Lyon.
Honestly,
when I see the result of that election.
Because, Ayo, for David Lyon's case, he was already preparing, the parade.
Yes, now, dress rehearsal for inauguration.
And then this happened. So for
they
Sylva,
brought in Nollywood stars, superstars. They paid them.
Of course,
to go to Bayelsa to come and perform.
It was going to be a big ceremony.
Oh no!
But unfortunately, that happened to him. But it's like the APC yet they've still not they learned any lesson, because even I heard even the deputy governorship candidate, is also having issues.
That is an ex-convict.
Ex-convict and all that, which they'll still have to contend with. So, but this one, just like Bikio said, the Supreme Court will be the one to really help us out, because there's also the issue about Section 285, whether the matter was actually filed at the stipulated time, which is the 14 days after the primaries, because if not, it means we can also look at that part, apart from the fact that even the person who took the case to court is not a party, was not in the primaries, which the Electoral Act, which DK mentioned, Section 29, as well as Section 84 of the Electoral Act, says that if you did not participate in that particular primaries, you can't bring that kind of case to the court. So we will look at it how the Supreme Court, in their wisdom, it is the Supreme Court that will decide in their wisdom. Because if they look at it by merit and say, oh, you were sworn in for that 1 year, between May 2007 and 2008, you were a governor, and then come again, and you became governor in, when was that? In May 2008, and then in 2012, he was also governor. If they look at it, it means he was sworn in twice. So the Supreme Court will have to look at it and say, well, based on what we have and based on our constitution, you can only spend 2 terms, which is 8 years. So you can't spend 9 years. So it's just a very tricky judicial matter. It's very, very tricky. Even there's no lawyer that will tell you that it's going to go this way or that way. So we just want to allow the Supreme Court, to do their work.
If peradventure this does not get to the Supreme Court before the election, this will also have a negative effect in whatever the outcome of the election might be. Let's say a candidate of APC now wins the election.
It will turn to another. It will turn to another.
It's not ruling after that election. The team, it will have effect.
No, if they manage to do the election and they swear him in,
really?
Because it will now be treated as a pre-election matter.
Pre-election.
And pre-election matters are time-bound. That is
reality.
Yes, they are time-bound. David Leon had not been sworn in, so he had no immunity. They had not been sworn in, so you cannot treat it as a post-election matter. Once a person gets sworn in, it is the tribunals that will handle his matter. And if we bring this kind of matter before the tribunals, they are going to say that, look, there is no jurisdiction, this is a pre-election matter. Of course, it's a pre-election matter, So I believe that the Supreme Court itself had ruled in the past that nobody can expand the scope of the Constitution. And the Constitution is clear about the number of years that you can serve as governor or deputy governor. So that's why I said, as the court of policy, Supreme Court can decide that, okay, in spite of the fact that the person who brought this matter had no locus, this is our judgment. It's within their right. They can assume. Remember, even the Naira redesign matter. Many people felt that Supreme Court had no jurisdiction on the matter, but they assumed jurisdiction. That was the first issue that came up. They assumed jurisdiction and then eventually gave their ruling. So, as a court of policy, I cannot say this is what Supreme Court will do, but this is an interesting matter. You cannot do more than
between now and November that the election has been scheduled. It's going to be very interesting. Well, with this step now, it will also be expected to go to the Court of Appeal or to the Supreme Court.
Yes. They are going to the Court of Appeal already.
So they can't jump that. The Supreme Court cannot assume jurisdiction directly because it's not a constitutional matter.